In the last class, we have discussed about the primary sections of the TP Act, and we have also discussed that how the provisions of the TP Act is important for the transfer of the property. So, we have also discussed up to some extent in the interpretation clause. And in the interpretation clause, we have discussed about certain interpretations in a very detailed manner also. So when we're talking about the immovable property, the instrument, the attested, then we have already discussed about all these things in a very detailed manner before. So having a small brief about the thing we have already discussed. When we're talking about the immovable property, we know that that is indicating a certain kind of property which is non-movable in nature. Okay, if any property cannot be shifted from one place to another, that is called the immovable property, and that is what we have already discussed in the last class. In the same way, when we have discussed about the movable property, then also in that case we know that when there is a property is called the movable property, that means when you are calling a property as the movable property, that means the property can be moved from one place to another. That is called the movable property. For example, just like we have discussed, the things we are seeing our outside, the ready-made things we are using our day-to-day life, those things are called the movable property. And the thing which cannot be moved from one place to another, that means when one thing is actually attached to the earth or being specifically attached at a specific place, just like the standing timber, growing grass, the home, these things are called the immovable property. That means whenever you are doing the ट्रांसफर ऑफ द प्रॉपर्टी ऑफ योर होम, अब जब आपका घर का प्रॉपर्टी ट्रांसफर करते हो तो क्या आप अपने घर को ही ट्रांसफर कर देते हो, मतलब घर को एक जगह से हटा के दूसरा जगह को ले जा सकते हो? द आंसर इज नो. व्हाट यू आर ट्रांसफरिंग इज द ओनरशिप ऑफ द होम. घर का जो भी ओनरशिप आपके हाथ में है, आप वही ओनरशिप का ही ट्रांसफर करते हो. दैट मीन्स द हाउस इज स्टेइंग एज द प्लेस इट इज. घर जहाँ पे था वहां पे है और वहां पे ही रहेगा. अगर कोई चीज ट्रांसफर हो रहा है तो वो हो रहा है घर का ओनरशिप. मतलब अगर घर पे पहले कोई रहा करता था तो अब और कोई रहा करता है. गट इट ना. So in so these things, in the case of the movable property, the ownership or the right on the property is being transferred. The whole property, the whole immovable property is not being transferred over here. Okay. So this is what we have already discussed in the under the transfer of the property. And then we have also discussed about the instrument. That is what we discussed, that is what we call about the non-testamentary instrument. Then you might have asked me that what do you understand by the non-testamentary instrument, the instrument which is not testamentary in nature. That means the instrument which is not being genetically transferred or inheritically transferred from one person to another, which is not gained by the inheritance or which is not transferred by the inheritance, that is called the instrument, and not, that is specifically called the non-testamentary instrument. The instrument which is non-testamentary in nature or non-inheritance in nature, जहाँ पे आपका इनहेरिटेंस और पैटर्नल प्रॉपर्टी, मैटरनल प्रॉपर्टी जो ट्रांसफर होता है इनहेरिटेंस बेसिस पे, वो नहीं होता है. जहाँ पे those kind of the property has been dealt has been dealt in the uh, right of the inheritance and जो Hindu Succession and Inheritance Act, that is a different specific act for those provisions. But in this provision, these sections, this specific kind of transfers is not being dealt. The non uh, as I told, the non-testamentary instruments has been discussed under this whole sections of the TP Act. Okay. Then comes your attested, as like I have already explained to you when we are talking about the attestation of a property. The person who is doing the attestation, that is called the executant, he must do it, or any person on behalf of the executant must do this. Okay. So who can do the attestation? The executant or any person on behalf of the executant. Okay. And secondly, there is the presence of the two witness, minimum two or more than two witnesses, that is mandatory or necessary to be present at the place of the attestation. And we have already discussed that those two witnesses, they are not necessarily always to be present at the place of the attestation. For example, there are three witnesses. Two witnesses are present at the place of attestation, but one witness is not present at the place of attestation. So, in that case, the uh, the person who is the witness must get the must receive the acknowledgement of the signature or mark of the executant from the by the executant or with the instruction of the executant. Okay. So what does it mean? For example, there is a person who is referred as the witness, but that person is not present at the place of the execution of the deed. Okay. Or at the place of the attestation. So what will happen? In that case, it is the duty of the executant or the person who is doing at the instruction of the executant, any one of them, if the person is absent, if the witness is absent, to send a copy of the execution with the attested signature or mark of the executant to the witness, that it is the proof that yes, the execution has been done properly with the signature of the executant or with the representative of the executant. Okay. So in this case also, uh, the witness, whoever has received this kind of the acknowledgement of signature or mark of the executant, is also considered as a witness. Okay, because that the witness of that specific person is also considered as a valid witness itself. Okay. Then comes the person of the registered. So under that we have discussed registered, any part of the territories to which this act extends under the law for the time being in force, regulating the registration of the documents. Registered means when something has been registered in the pen and paper through the all the official procedure and through the documentation, that is called to be registered. Okay. Then comes attached to earth. Attached to earth means something which is uh, rooted in earth or embedded in earth. Okay. That means, for example, I tell that something is attached to earth. That is something rooted in the earth, as in the case of the trees and shrubs. Shrubs, trees also, So when a tree and shrub is rooted in the earth, the root of the tree or shrub is inside the earth, that is called to be attached in the earth. Okay. Or rooted in the earth. Second, embedded in the earth. So when something is uh, basically just touching the earth and it is closely connected with the earth, closely embedded with the earth. It is not disconnected from the earth. For example, there is a home or there is a building. It is not rooted in the earth, but it is embedded in the earth. The base ground or the basic ground of the home, the basement, that is actually embedded where? To the earth only. Got it? So it is called embedded in the earth. And the third one, attached to what, so embedded for the permanent beneficial enjoyment of that which is attached. Okay, that means attached to what is so embedded for the permanent beneficial enjoyment that to which it is attached. Means the thing which is attached, that is for the permanent benefit of the beneficiary. For example, there is a tree which is rooted in the earth, and that is rooted for the permanent benefits of the persons living around. For example, there is a home that has been built, and the home is been made for the permanent living purpose of the people of the home. Okay, or there is a buyer of the home, that the person who is buying the home from the seller, that person is becoming the permanent beneficiary of the home, right? So this is called that when some person is enjoying the permanent benefit of something which is permanently attached or embedded to earth, that is also considered under the clause of the attached to the earth. Okay, next we have discussed the actionable claim. Actionable claim, we have discussed that when we are talking about the mortgage of the um, movable property or place of the movable property, the beneficial interest in the movable property is not in the possession, either actual or constructive. In that case, this is called, such debt or beneficial interest is called the actionable claim. Moreover, the any kind of the debt or beneficial interest on the movable property, okay, which is actually existent, accruing, increasing, conditional or contingent, that is called the movable property. Okay, so if we are talking it exactly, then it is specially means that it is a right to claim a debt or benefit in a movable property that the claimant does not currently have in their possession, either physically or constructively, indirectly. The claim can be recognized in the civil court as the legitimate basis for the legal action, whether the debt or benefit is currently due, expected to be due, or in future, conditional, or even uncertain. Okay. However, the debt secured by a mortgage in a movable property like house or hypothecation or place movable property are not considered as the actionable claims. Okay. So when there is the debt or benefit, the claim of a debt or benefit in a movable property, that is called the actionable claim. The claim or debt on a immovable property, that is not called as the actionable claim. Okay. And next, we have discussed, and yes, the claim or debt. The debt or claim or benefit in a movable property that the claimant does not currently have in their possession. Okay, that means the person, the claimant who is doing the claim of the debt or the benefit from the property, the person must not have the possession of it right now, but the person is claiming the debt or profit from that specific property. That is called the actionable claim. So let's take an example of this. For example, um, for example, you have taken the amount of the loan of the 10,000 rupees from me, okay, and you are unable to repay the debt, okay. So when you are unable to repay the debt, then you are telling me that, ma'am, I am having a machine or that machine is being used for my home or in my ground for the cultivation purpose. Okay, and I want to give it that property to you for the duration of 1 year or 2 year. You keep it, you take the benefit or enjoyment of this. I am unable to pay the debt, but I am giving this specific movable property or this machine to you for your benefit or for your enjoyment. So once the duration of 1 year or 2 year is being fulfilled, then you can just give it back to me. So here, when I am claiming the interest or the benefit or the enjoyment right from the movable property, which the claimant, that means me, I don't have the current position, the direct physical possession or indirect possession on that property. You are the owner of the property, but I am claiming the benefit from that property, okay, on in the exchange of the debt which I have, which you have taken from me, okay. So when there is the claim of the debt or benefit from a movable property which is not in my possession right now, but I am claiming that that possession of the property or that enjoyment of the property from you, and that property is the movable property. That kind of the claim is called as the actionable claims. Okay. Then there is one more provision we have discussed, that was about the notice. So when we are talking about the notice, you may ask that when we can talk that a person is having the notice of the thing. The first thing is, we'll call that the person is having a notice of a thing, that when he actually know about it. And the second point is, they would have known about it if they had not deliberately avoided investigating, or if they had not been grossly negligent. There are two situations when we can say that the person has the specific information about the thing, or the person has the notice about the fact. The first point, when the person actually know about the fact, that the person knows that yes, this is the fact, this is the reality, or this is the thing that has been happened, or something like that. Okay, when the person actually knows about a thing, that is called a notice, the first point. The second point, they would have known about if they had not deliberately avoided investigating, or if they had not been grossly negligent. That means, if the person have done a little investigation upon the fact, if the person has not been negligent about the fact of the matter, then the the notice of the fact would have come in front. For example, I'm buying a house from you, okay. So when I'm buying a house from you, I am totally negligent about the existence of the house. For example, you are coming to me, you are telling me that, ma'am, there is a house at this location. So I want to sell it. Are you ready to buy that house? Then I'm telling that, okay, I want to buy the house. Okay. So here I am totally negligent about the property which I am buying. I'm totally negligent. I have not done a simple investigation even that what this property belongs to, who is the real owner of the property, and what is the basic requirement of the property, and how the property is being dealt. I have not done a simple investigation about the property because I was negligent about my duty of doing the investigation about the property. Got it? So this was my duty to do that, but I didn't do my duty over properly over here. If I would have done a simple investigation, if I would have even gone to that location, I would have asked the localites that what is the matter over here, or is this property really belong to this person? Then yes, I would have got the detailed information that you are lying to me. But instead of doing any kind of the investigation, I blindly trusted you and I entered into the notice of it. So here, even if you are doing a fraud with me, I'll be called as the notice of the fact that I have got, because the notice of the fact that I have not got, that is due to my own negligence only. That is not due to, that is that, yes, I accept that here there is a fault at your part because you have done a fraud with me, you have done a negligence with me. But it is also my part of the negligence that I didn't look upon the matter and I didn't do the proper investigation into the matter, that what I could have done. As I am lacking as my part of the duty, that is why I can call upon that this is where that I have also got the notice of the fact even if I have not got it. Got it? The next point we are talking about the explanation one of this. Okay. So in the explanation one, we are talking about the notice in the transactions involving immovable property. Okay. So when a transaction regarding the immovable property, land or buildings is legally required to be registered and the registration has been completed. Okay. When a transaction regarding the immovable property, the land or building, is legally required to be registered and the registration has been completed, anyone acquiring that property or an interest in the consideration to have notice of the registered document from the date of registration or the earliest filing date if the property is registered across multiple sub districts. Okay. So So when we are talking about the notice in the transactions of the immovable property, that is specifically means it might be a land or building that must need to be done with the legally required registration process and that must follow all the process of the registration. So there are basic requirements of this, the rules that is applied over here. The first rule is the document must be fully registered as required by the Indian Registration Act 1980 and its regulations. The regulation of the Indian Registration Act 1908 is being applied, and hereover the document must be fully registered according to the Indian Registration Act. The second point, the document or memorandum of it must be recorded in the official registry. That means the document or the memorandum that has must been recorded in the official registry. That means whatever the documentation is being done, that must be officially registered. The third point, details of the transaction must be correctly listed in the indexes under the relevant section of the Registration Act. That means the deed or the agreement, whatever it has been done, it must done with the indexes or the clauses of the proper relevant section of the Registration Act. That means the proper section of the Registration Act must be applied and it must be done with the proper rule and regulations. Then the explanation 2, it speaks about the notice of the possession. If a person buying the immovable property or an interest in it, they're assumed to know of any other person's right to that property if that person is actual possession of it. Okay, so what does it mean? If a person buying immovable property or interest in it, what does it mean? There is a person who is buying a property or who is having the interest on that property, they're assumed to know of any other person's right to the property if the person is the actual possession of it. Okay. So, for example, I am going to buy a property of yours. Okay. You are selling me a property, I'm buying a property from you. So, it will be assumed that this is my right of the property to know that are you the actual owner of the property. Even if I don't have the idea about this, it will be assumed that I have the idea upon the specific thing. Okay, let me explain it in a detailed manner. There are two situations. Okay, at first, I'm giving you an example. You are coming to me, you are telling me that, ma'am, I have a home at the at Delhi, and I want to sell my Delhi home. Then I asked why, and because I'm not staying there, and I want to sell that home to you. I said, okay, sell it. I'll buy that home. So before buying the home, what I did not do any proper investigation. I just bought the home. I just given you the payment and I just bought the home from you. Later, I got to know that you were not the real owner of the home. So here over, the situation is, if I would have done the proper inquiry, if I would have not shown my negligence towards this property or towards the buying of the property, then I wouldn't have faced this kind of the fraud. This is my negligence that I did not investigate to know who is the real owner of the home. This is the first situation. And here, even if I have, I didn't have any idea that you are not the real owner, or I am doing it with a very good faith. I'll be considered that I had the idea that the property doesn't belongs to you, and even after knowing that, I am buying the property. This will be considered. This will be assumed, even if it is not true. The second situation, I don't have any idea that you are not the real owner. Even and I don't have any scope to know this that you are not the real owner. Okay. Even if I am doing my best to know this, even if I am doing the trial to know this, that is this person the real owner of the home, even if I am trying my best to do the investigation upon this, I'm unable to find the real fact because you have concealed the fact from me and you have shown me a clear scenario where I was bound to trust you that you are the owner of the property. Here, I am not responsible for the for my negligence or for this not having the knowledge of the property. And here, it won't be assumed that if I had the idea that the property doesn't belongs to you. And here I won't be liable for my part of the negligence. So you may ask why. In the first situation, I told you I didn't do my proper investigation to know the fact. But in the second situation, I did my best to know the fact. I did my proper investigation. I inquired into the fact. I went to the places. But in all over the places, in all over the circumstances, you have created such a situation that I was bound to believe that yes, this property belongs to this person. So this is a fraudulent activity towards me, which I was unaware of. I didn't know that this is the fraudulent activity that is happening to me. And I was totally unaware about this happening of the event. Here I have shown my proper care and caution for the act. Here I have shown my proper carefulness, proper concern, proper investigation into the matter. But even after doing the proper investigation, I am unable to find the root of the fact that you are not the real owner. So here, if I am buying the property from you, I won't be liable for my own negligence because I have not done any kind of the negligence over here. The next point we're talking about the explanation 3 that speaks about the notice through agents. What does it mean? If a person's agent or representative learns about a fact while doing business on behalf of the person is also considered to have notice of the fact. However, if the agent conceals this fact in the fraudulent way, the person will not be considered to have the notice if the other party involved in the transaction knew about the fraud. Okay, so this is a very, very important thing. I'll explain to you. The first thing you must have heard when we are talking about the law of the tort, we have heard there is a provision that was called as the master servant relationship. Did you ever hear about this? The master servant relationship means the master is liable for the activity of the servant. That means if I am having a servant at my home, then whatever the activity my servant is doing during the working period, I am liable for the activity of my servant. I am having my own employee or I am having my staffs in my office. So if I am sending my staff for a certain activity, for a certain work, and there is a misrepresentation or there is a mistake is being done by my staff during the working period or of the work, then including my servant, I will be also responsible for that situation. All the blames of that incident or the accident or the mistake will not go to my servant only. I'll be equally responsible for this non performance or for that specific kind of the mistake. This is what we have already discussed. The first and we'll discuss it when we learn the law of torts. Okay, this is called the master servant relationship. Okay, so here when there is a representative of a person, he is getting to know about a specific fact of an agreement or of a transfer of the property, then this is the duty of the agent to inform the person about the same. For example, I am running a company, I'm running a business. So I have sent one of the staff to your home for a specific kind of the service. So that staff is going to your home and he is delivering my business. And during the course of the business, you are informing my staff about a certain thing that yes, this is the thing, this happened or something like that. Then what happened? This is the duty of my staff to come back and inform me that ma'am, this is the thing. This has been informed by the client and this is the circumstances that happened. So here I should know the happening of the incident through whom? Through the staff itself. Who is responsible to inform me the data or the fact you have informed to him? The staff, my representative. Yes. For, for example, the staff didn't inform me about the fact. He concealed the fact. He has hide the fact. And you are the innocent customer of mine. You don't know about this fraud. Like neither I nor you, none of us know about this fraud. This is the agent or the representative who did this fraud. So here, who will be responsible for the non-performance? For example, you asked him for a specific kind of the service, but the staff knowingly with the intention of causing harm to me has hidden the fact from me and didn't inform me. That is why the timely delivery or the timely service which I would have provided you if I would have known about the fact, I couldn't do it because I was not aware about the fact over here. So as I was not aware about the fact, I couldn't able to provide the service to you. And here in this place, the notice which could be delivered by my agent that was not been delivered. Here, who will be responsible for your losses? Is the only agent who will be responsible for the losses? No. Even if my agent has done this fraud without my consent, but this has been happened by my staff, and as the staff is the part of my company, I am equally responsible for this non-performance or for this fraud or for this mistaken activity, and I have to pay the compensation to you for this activity. The second condition, the customer is also involved in this kind of the concealment. That means the representative or the agent has hidden a fact from me, but also simultaneously you have the idea that this is the fraudulent activity that is going to be done. You knew it before, आपको ये बात पता था, but even after knowing this, that my staff is going to do the fraud with me, and you are collabed with him or her, you know that this transaction is a fraudulent transaction, that my representative is going to hide this fact from me, the customer or my servant, whoever is, everyone is aware about it. This is the joint activity by the customer and my representative, the person to whom the service has been delivered, the property has been delivered, and my representative. This kind of the fraud has been happened to me with their joint concealment. Here I won't be liable to pay you a single penny of the compensation because this is not my part of the fault. If my staff or my representative is doing any kind of the concealment of the fact, that is also being done with your instruction, you are involved in it. That is why, how can you claim compensation from me? You cannot. Got it? Then the next point, we are proceeding to the definition of the transfer of the property that has been discussed under after the interpretation clause under section 3 of the TP Act. Okay, just 1 second. Yeah. So next comes our, after the interpretation clause, there is the exceptions, explanation. We have discussed all the explanations discussed over here, and this is how the interpretation clause has been completed. The first section explains about the short title and extent of the act. The second speaks about the repeal of the act. The third speaks about the interpretation clause, which is very, very important, and we have also discussed each of the interpretation clause with the exceptions and explanations. Then comes section 4, which comes about the enactments relating to the contracts as taken part of the Indian Contract Act and supplementary registration. That is not that much important. Then the most important clause, sorry, most important section, section 5, it speaks about the transfer of the property, and it explains that transfer of the property defined. In the following sections, transfer of the property means an act by which a living person conveys the property in present or in future to one or more other living persons, or to himself and more than other living persons. And to transfer property is to perform such act. Transfer of the property means the transfer of the property. So when we are talking about the transfer of the property, the property can be transferred to whom? The property must need to be transferred to a living person. And most importantly, remember it, the property can be transferred to the person himself. If I am the person over here who is transferring my property, there is a provision also that I can transfer my property to myself. So this transfer of the property and the concept of the living person to whom the property can be transferred is being defined under the chapter 2 of the TP Act. This chapter 2 explains about the transfer of the property and then discuss that what kind of the property that can be transferred, and who are the persons competent to transfer. Under the section 6, which speaks about the what kind of the property may be transferred, under that it has also been discussed that what are the kind of the property that cannot be transferred. So except the property which cannot be transferred, all other kind of the property is being transferred. So from section 5 chapter 2 onwards, where the transfer of the property has been defined, and all other provisions we are going to discuss in the next class. This is all for guys. We can wrap the class over here. Thank you. Bye bye. Take care.